The broadcast is now starting. All attendees are in listen-only mode.
Well, good morning or afternoon, depending on where you are located, and thank you for joining us for today's webinar on gun trust, which is presented by attorneys Alan Gassman and Sean Healy. My name is Deb Erdman. I'm a Vice President and Trust Officer with Peak Trust Company, formerly Alaska Trust Company, and we are the sponsor of today's webinar. A little bit about Peak Trust. We're a full-service trust administration firm with offices in Anchorage and Alaska. We were started 20 years ago in Anchorage, and in a move to grow and expand, we came to Nevada in 2016 when we changed our name to Peak Trust. Some housekeeping items for today's webinar is that we will be recording this, and a copy of the slides and the recording will be emailed to you within 24 hours after the webinar. So those of you that want a copy of the slides or can't get to the webinar or want to rehear it, we'll be sending that to you within 24 hours. We will also have Q&A at the end of this session, so please feel free to send your questions during the webinar, but just note that we won't be answering them till the end. So on the right-hand side of your screen, you'll see that panel. And in there is a question box, and that's where you'll type in your question. So with that, it is my sincere pleasure to introduce our first speaker, Mr. Alan Gassman. He is an attorney practicing in Clearwater, Florida with the firm of Gassman Law Associates, PA. Mr. Gassman's primary practice focuses on, over the past 26 years, have been the representation of high net worth individuals, physicians, and business owners in estate planning, taxation, and business and personal asset structuring. Alan speaks often for national and state-sponsored continuing education programs. He publishes several articles each year in publications such as Bloomberg's B&A, Estates and Trust Magazine, Estate Planning Magazine, the Florida Bar Journal, and Lineberg Estate Planning Network, and of course the co-author of the book The Legal Guide to NFA Firearms and Gun Trusts. So with that, it is my sincere pleasure to turn it over to you, Alan.
Well, thank you very much, and thanks very much to Peak Trust Company. If you're attending this webinar and you have not used or met Peak Trust Company, you really need to, because they understand how these trusts work. They've been in Alaska since the 1990s. And if you've never had Brandon Centula review one of your trust agreements, you've never had as thorough of a review of a trust agreement as you'll ever see. He's really bright. So one of the things that happened to me last year, which was a wonderful thing, was that Jonathan Blotmacher asked me to get involved with writing a book that was going to be called The Legal Guide to NFA Firearms and Gun Trusts. And I have to admit that last year, I didn't know much about gun trusts. And I said, Jonathan, I'm sure I can figure this out, but who's going to help us? And Jonathan said, don't worry, because I know a guy who knows more about gun trusts than anyone in the country. And when Jonathan Blotmacher says something like that to you, you know you need to brace yourself to meet some real talent. And I was not at all surprised at how bright, how articulate, and how knowledgeable Sean Healy is. Of course, he's the general counsel for the National Mensa Association, but beyond that, he is an editor, a writer, and a representative of gun interests throughout the country. He is the Texas State Rifle Association's general counsel. He's the NFA editor for Interactive Legal's module on firearms, which you really should check out if you're not aware of it. He's going to talk a little bit about that. And he's also a concealed handgun instructor. He teaches pistol, rifle, shotgun, muzzle loading, and gun safety. He's a nationally trained instructor trainer for the Texas 4-H shooting sports, and he is a great guy. So he's really going to lead the discussion today. The only thing I'm going to do is tell you a few things, one of which is please consider buying our book. The book is on CreateSpace, and I've got a code here for you for a $10 off. It's also on Amazon, and all of our net profits from any and all sales for the next 10 days are going to go to the Ronald McDonald House charity. There is a Ronald McDonald House next to the Johns Hopkins All Children's Hospital in St. Petersburg, Florida. And every dollar you spend on the book, minus about $5, which is the printing cost, is going to help those kids at the Ronald McDonald House. So please consider the book, which Sean did a masterful job of writing. And we've got a table of contents here. Your alternative is to go ahead and subscribe to the Gun Trust channel at Interactive Legal, and then the book comes to you free of charge. And the book includes all the ATF forms, letters to clients, all sorts of things that are very valuable. What I want to try to do for those of you who are novices in this area and those of you who are refreshing your memory, I just want to go over some terminology, and I'm going to have some questions which Sean is going to answer. But on the page you see here, a gun trust or an NFA trust is the trust that you set up to own regulated firearms. Now, this is not all firearms. This is automatic weapons, suppressors, and short-barreled rifles. So when you have clients with these types of weapons, there are very special rules that we're going to discuss, and thus, quite often, the need for a gun trust. And then you have two different federal laws that we need to be aware of. One is the Gun Control Act of 1968, which restricts the transfer of these types of firearms, and the other is the National Firearms Act. And you need to know that these rules are administered through the Bureau of Alcohol, Tobacco, Firearms, and Explosives. A Title II firearm is the type of firearm that is very highly regulated in the United States. These are, as I said, the short-barreled rifles, the short-barreled shotguns, suppressors, which are also known as silencers, and certain other destructive devices. Now, a transfer is what you can't do without complying with this law. And possession is what you cannot get or give without complying with these laws. Constructive possession is illegal. It would be illegal for me to have an automatic weapon in the trunk of my car and to have my secretary drive my car somewhere with access to the trunk, even though she doesn't touch the trunk. It would be illegal for me to leave an automatic weapon out in a room where somebody else walks into the room and would have the ability to pick up that automatic weapon. And it would be very illegal for me to allow someone to use my automatic weapon unless they are the trustee of a trust that owns the automatic weapon. And that's why these trusts are so important, because you really can't share use of an automatic weapon or even a silencer without complying with these rules. Now, if you are a responsible person, then you must submit fingerprints and photographs to the alcohol and tobacco folks. There has to be a background check, and this includes the initial trustees of the gun trust. It may not include trustees that are added later on, and that can be important for your planning. You have to make darn sure that you do not have a prohibited person with access to the gun or as trustee of the gun trust. So this includes anyone using cannabis, even if prescribed in a state that allows medical marijuana. So you have to be careful here, and we want the gun trust to strictly prohibit anyone who is a prohibited person from having access to this gun. However, a prohibited person may be the beneficiary. If I die and I want my collection to go to my grandson, who is not of legal age or who presently has a marijuana problem or even a criminal background, I can entrust the gun to the trustee of a trust who can withhold possession until my grandson straightens out and can become a responsible person. Now, the chief law enforcement officer of where your client lives, known as the CLEO, needs to be informed of the gun trust and the gun, the automatic weapon. It used to be that you needed their signature in advance of acquisition and consent, and they weren't all consenting. Now they just need to know the information. And as we've said before, a machine gun is the shorthand term for an automatic weapon. That means more than one shot per pull of the trigger. A semi-automatic gun, where it's one shot per pull of the trigger, is not subject to this regulation unless it's a short-barreled rifle or a short-barreled shotgun. For the rifle, it's 16 inches to be short. For a shotgun, it's 18 inches to be short. Then there's some confusion over 18-year-olds and 21-year-olds. An 18-year-old can be the trustee of a gun trust, can be permitted to own these firearms, but people under 21 are prohibited from possessing handguns and handgun ammo. The other thing I'll mention, which I'm sure you know, is that every state has some laws relating to these types of weapons. So you need to check not only our book and future changes in the federal law, but also the state law. Some states will defer to the federal law, but many won't. And although your gun trust may be fine under Florida law, if your client, and Texas law, if your client is driving with these guns through Georgia and Louisiana, there could be issues. So we have to keep this covered. Finally, on page 10, I have a chart for you, which helps to point out why gun trusts are so popular and so useful. If you purposely own and have one of these regulated items, you can't share use with anyone legally. Maybe you can share use if you are immediately with them and supervising them. Sean's going to speak to that. If you put these items into a limited liability company, then it may be possible for each of the managers or officers to have access, but you're not going to have a reasonably regulated document that provides them with the instructions that a gun trust has. And if and when the limited liability company is accidentally dissolved by the Secretary of State for not filing its annual fee, you have committed a federal felony. And even though you can retroactively reinstate the LLC under state law, that does not unring the bell on the felony. So we far prefer the gun trust. The gun trust not only handles all of these issues and does not need to file an annual report, it can provide a degree of confidentiality as to beneficial ownership and future trusteeship, and it can be the inheritance vehicle and also possibly an asset protection vehicle and also possibly a liability limitation vehicle for the beneficiaries and future beneficiaries of the trust. So I'm going to turn this over to Sean now. And Sean, I'm going to give you control of the slides, and I'm going to look forward to your presentation.
Thanks, Alan. I appreciate all the kind words you said to me at the beginning of this, and I think you were too kind, at least in one respect, and that is that I may be the lead author on this book, but you did all the groundwork and all the legwork of getting this thing ready to go. I just made a few changes to it and all that. So I just lost the PowerPoint presentation. I'm trying to get it back up. Can everybody see the presentation?
Yeah, we see it, and I can turn the slides if you've lost it, if you have a printed copy in front of you.
Yeah, if you don't mind running that just for a little bit, that would be helpful, because it just went off of my screen and I'd have to go back to another folder to get it up there. Okay, you've got that now?
Yeah, we're on page 13.
Okay, thanks. Okay, the first question that everybody might have when you first hear about this is it a good idea to let private citizens have things like machine guns and suppressors and destructive devices? And to answer that, I've done some research and looked into the history of how many crimes have been committed by these items. And a couple bullet points on this history. First of all, there are only two documented murders that were committed with a legally owned machine gun since 1934, when the National Firearms Act was enacted. One of those was by a police officer, and of course, if you look at these laws, they're exempted and allowed to have these things anyway. So since 1934, two documented murders with a legally owned machine There were 4 police officers killed with illegally owned machine guns between 1983 and 1992 out of a total of 713 officers killed. So that's less than 1%. You can look into other NFA firearms, specifically suppressors. There's a report that an attorney wrote about the crimes committed with suppressors. I can give you the citation of that later on if you want to, but the bottom line is the ATF director testified to Congress in 1987 that registered machine guns which are involved in crimes are so minimal so as not to be considered a law enforcement problem. The chief law enforcement agency governing firearms doesn't think this is a law enforcement problem. So part of that is because of the background check that people have to go through to be allowed to even take possession of NFA firearms. But if the police don't believe it's a problem, then I think we can rest assured that it's not a problem. Could you go to the next slide, please?
Got it.
I apologize for moving so fast, but we've got a whole lot of ground to cover here. I have summarized the legal principles that we're going to be talking about today, and they come down to 6. If you understand these 6 legal principles and can hold them all in your mind simultaneously while you're drafting a trust or doing any work in this area, then you're going to stay out of trouble. These 6 legal principles are behind every provision in the trust and the other documents that we draft and basically everything we do in this area. The first one is that possession of an NFA firearm is prohibited by anyone other than the registered owner. And Alan gave you the definition of the NFA firearms. That includes machine guns, which is any firearm that shoots more than 1 projectile with a single pull of the trigger. Silencers or suppressors, short-barreled rifles or shotguns, destructive devices, and any other weapon. Destructive devices include like 20mm cannons, even larger cannons, and then some explosive devices like hand grenades, and then any other weapon involves some exotic collectible guns like pen guns and firearms that can be fired from inside of a briefcase and things like that. But for all intents and purposes, the ones that are commonly owned are mostly suppressors, and then after that would be short-barreled rifles and shotguns and machine guns. So you can't possess one of those items unless you're the registered owner. If you're the trustee of a trust that owns the firearm, or if you're an officer, director, or a manager of a business entity that owns the firearm, then you're allowed to possess them. Second principle is that applies to transfer of NFA firearms. In order to legally transfer an NFA firearm, you have to submit an application, you pay a tax which is normally $200, and then the application has to be approved with a tax stamp and sent back to you. Only at that point is the transferee allowed to take possession of the NFA firearm. And a new regulation was passed in 2016 that requires the application to include information on responsible persons, and that regulation replaced the old requirement of getting your local law enforcement to endorse that application, got rid of that and replaced it with a new requirement that you just have to notify your law enforcement officer. And that notification goes to the law enforcement officer over the county where each responsible person is, and then also of the county where the trust is to be located. The third legal principle is that trusts are persons too. The reason that is that the National Firearms Act is enacted through Congress's power to tax. It's not a regulation of interstate commerce. And because of that, it's governed by the Internal Revenue Code, which defines a person to include trusts and business entities. That's why we're allowed to have trusts that own NFA firearms, because persons are allowed to do that, and the tax code defines person to include trusts and entities. The fourth principle, as Alan mentioned, is that it's illegal for any prohibited person to possess any firearm or ammunition. That's from the Gun Control Act, but it applies to NFA firearms and to normal guns like rifles, pistols, and shotguns. If a prohibited person takes possession of a firearm or ammunition, that's a felony. If a prohibited person has constructive possession of a firearm or ammunition, that's a felony. If you provide a firearm or ammunition to a person that you either know or have reason to believe is a prohibited person, that's a felony. So the bad guys can't have guns, and that not only includes felons, but there also are 9 other categories of people who are prohibited from ever possessing firearms or ammunition. Now, some of those are temporary statuses that can be removed. The 5th principle is that you also have to comply with state law, and some states have additional restrictions on NFA firearms, and some of them even prohibit civilians from possessing them. And then finally, the 6th requirement is that if you're going to form a trust to own these items, that trust has to be valid when it's formed, and it has to remain valid and in existence during the entire time when it has NFA firearms registered in its name. The reason is that, again, principle number 1 prohibits anybody other than the registered owner from possessing an NFA firearm. If the registered owner is a trust and that trust doesn't exist, then the individual person who possesses that item at the time is committing a felony. Next slide, please. And Alan, if you can switch over control to me without having to put the other screen up, I don't mind taking control either way. These are the definitions of the NFA firearms. We just went over those. Machine guns, suppressors, silencers, short-barreled rifles and shotguns, disruptive devices, and any other weapon. Next slide. This is an example of a state law that governs NFA firearms. This is the Texas Penal Code section, and the first 4 categories here basically parallel the 4 of the categories of NFA firearms. Explosive weapons includes a lot of destructive devices. Machine guns is basically the same thing as a federal definition. Short-barreled firearms is basically the same thing as short-barreled rifles and shotguns. And then silencers is the same thing as the federal thing they call a silencer or a suppressor. Now the switchblade knives thing has been changed. That's not an NFA firearm. Brass knuckles, armor-piercing ammunition, chemical dispensing devices, and tire deflation devices. These are also other items that the Texas legislature added in and made prohibited weapons, but those are not governed by the NFA. So Texas has an example of a law that essentially says that it's illegal for someone other than the registered owner to possess those 4 NFA firearms. And then the other categories, it's not legal for any civilian to possess. Next slide, please.
You should have control now, Sean.
Okay. It still says now view an Allen screen.
Okay, sorry, I'll just keep doing them.
Okay. This is a chart that I created that helps you organize in your own mind the Gun Control Act versus the National Firearms Act. The Gun Control Act is the main law that governs guns, and it's primarily intended to govern normal rifles and pistols and shotguns, although it does apply to other ones. The National Firearms Act is the one that applies to exotic firearms such as suppressors and machine guns. And they both have a definition of firearm, and the NFA applies to firearms under its definition. The Gun Control Act applies to firearms under its definition. So the first cell up there, the upper left box, is the guns that are considered, or the items that are considered a firearm under both laws. A machine gun is specifically defined under the NFA as an NFA firearm. It's also falls under the definition of the Gun Control Act because it uses an explosion or burning of a chemical device to propel a projectile out of a barrel. Short-barreled rifles, same thing, specifically included in the NFA. They obviously constitute a gun or a firearm under the GCA. Same thing for all the other ones there under that first cell, the upper right box. Now, let's look at the lower left box. Those are the ones that are not a firearm under the NFA, but they are a firearm under the Gun Control Act. So that would include normal pistols, rifles, and shotguns because they meet the definition of basically a burning chemical fires a bullet out of a barrel, but they're excluded from the National Firearms Act because they're ordinary guns. They're not the exotic kind that the NFA regulates. Now you look at the upper right box, and there's some things that are a firearm only under the National Firearms Act. A suppressor doesn't go bang. It's not a gun in the ordinary sense of the word. It's an attachment to a gun. The NFA specifically defines it as an NFA firearm, so it's included there. But under the Gun Control Act, it's not an item that fires a bullet out the end of a barrel using a chemical, so it's not a firearm. Same thing is true with suppressor parts. The NFA defines suppressor parts as NFA firearms. So if you have a set of baffles or some internal part to a suppressor, that's considered a suppressor under the law. Same thing is true for certain machine gun parts and receivers that are necessary to assemble a machine gun. If you have an auto sear that converts a semi-automatic gun into a machine gun, the NFA defines that as a firearm, but obviously by itself it doesn't go bang, so it's not a gun under Gun Control Act. And then finally, destructive devices that are not firearms, such as missiles and grenades and things like that, they are NFA firearms, but they're not Gun Control Act firearms. And then finally, under the lower right side, there are some items that are not considered firearms under either law. Those include antique firearms, air guns, and then there are certain devices that are designated by the Secretary as a collector's item that are not necessarily likely to be used as a weapon. So this chart can help you understand if it's a firearm under whatever law, then it's covered by that law. If it's not a firearm under that law, then it's not covered by that law. So as you can see from the chart, some guns, NFA firearms are covered, the actual gun type of firearm are covered by Gun Control Act and NFA, and this will help you organize and see which law applies. Next slide, please. Okay, this is a list of the prohibited persons that we discussed earlier. These are the categories right here, and these are people that cannot have guns or firearms, at least during the time they fall into this category. As you'll note when you read through this, some of these categories can be temporary and others are permanent. Convicted felons, there's a technical definition of that. Fugitives from justice, unlawful drug users or addicts, and as Alan commented, that includes people who are lawfully allowed to use marijuana under state law. Federal law still considers that an illegal drug, and therefore if you're using it or even having a card, a marijuana user's card, ATF considers you to be a prohibited person. Persons adjudicated as mentally defective or involuntarily committed to a mental institution, there's a process to get your rights back that's mandated by federal law, and there should be a state law procedure. Texas does have one. Illegal aliens and persons with non-immigrant visas, persons with dishonorable discharges, persons who renounce their U.S. citizenship, persons who are subject to protective orders and similar orders, and then persons convicted of misdemeanor crimes of domestic violence. Also, anyone who is under indictment for a felony is a prohibited person until that's resolved. So that would also include people who are currently working through a deferred adjudication. And then if they, at least in Texas, if you get finished, then they go back and the judge goes back and dismisses the charges and it's like it never happened. That would restore your rights because you're no longer under that charge and you're not convicted. Next slide, please. Here's some other prohibited actions that are related. If you're under indictment, technically you can possess them, but you can't ship, transport, or receive them. And so obviously that would be a stupid thing to have one in your possession because you couldn't prove when you received it. So if you're under indictment, then you probably shouldn't have them, but technically you're just prohibited from those actions. As Alan commented earlier, people under 18 are prohibited by federal law from possessing handguns or ammunition that's only usable in handguns. There are some exceptions for hunting and approved activities and carrying it on your farm and things like that, and also if you have written permission from your parents. The definition of conviction depends on state law. So if under state law the conviction was expunged, set aside, pardoned, or the person's civil rights are restored, then it's not considered a conviction for purposes of this law, unless the restoration says that the person cannot possess guns. And then finally, the one I mentioned earlier, you can't sell or dispose of guns or ammo to a person that you either know or have reason to believe is a prohibited person. Next slide, please. These are things that you should put in your trust that your trustees cannot do. That ensures, or at least it protects you and gives them some protection, trying to tell them not to break the law. You want to avoid letting your client or their loved ones make an inadvertent violation of the gun laws. This is a screenshot of ATF Form 4. This is the form that you use to apply for permission to transfer an NFA firearm to a non-dealer. This is the most common form that's filed with the ATF in regard to NFA firearms, other than dealer forms. And you can look at this form if you want to. It requires the information on the transferee. It requires very specific information on the firearm, including the serial number of it. What that means is you can't send in a Form 4 and say, hey, I want to buy a suppressor. You have to tell them exactly what suppressor and tell them who the dealer is. And they will check the records to make sure that that dealer has legally has possession of that firearm before they'll consider your application. So there's a Form 3 that's a dealer-to-dealer transfer. The dealer will acquire the firearm from the manufacturer or another dealer or whatever, and then use Form 4 to try to transfer it to you. When you submit Form 4, you also have to send in the $200 tax and the other information for the responsible persons if you're dealing with a trust or an entity. These are the other, you see the list at the top of the form there of responsible persons, and they run background checks on those people to make sure that you don't use a trust and then put a machine gun in the hands of a felon. Next slide, please. Y'all are probably familiar with these definitions. A trust is a fiduciary relationship by which the trustee holds equitable title to property for the benefit of another person. Now, I will point out that ATF basically treats a trust as an entity. It's not a relationship or a capacity in the eyes of ATF, it's an entity. So if you change the primary trustee, ATF still has the trust, the NFA firearm registered in the name of that trust, rather than, for instance, Sean Healy as trustee for the Healy Family Trust. So a change in trustee in the eyes of ATF is not a change, is not a transfer. So you don't have to do a Form 4. That's an important thing, and it's a good thing that they see it that way, because that allows you to switch out trustees and all that without always getting the government's permission. Then we have the definitions of settlor, trustee, and beneficiary. The settlor is the person that forms a trust or donates property to it. The trustee is a person who holds a property in trust, and then the beneficiary is the one who receives the property. And a lot of times that means at the end of the trust, the property is either sold and then the proceeds or the property are transferred to the trustee. Next slide, please. These come from Texas, but I think the principles are generally the same. Now, the NFA trust that I created started with the standard living trust form for the state of Texas, the same one that people use to put all their significant property in trust and avoid probate. And that form has a very broad set of powers for the trustees. So go ahead and go to the next slide. The basic idea here is, if you're going to make someone your trustee, you need to be able to trust that person. Next slide, please. Basically, it allows, in Texas at least, it allows a person serving as trustee to do anything with the trust property that the actual original owner could have done if there wasn't a trust. Next slide, please. When you're drafting an NFA trust, your client, first of all, the purpose of an NFA trust a lot of times is not actually to have the trustees serve as fiduciaries. It's just to allow them to have the right to possess the trust property. For instance, to borrow a suppressor and go to the deer lease. So we still have the fiduciary duties in there, but you may want to have a provision in there that makes your client, if that's the person that paid for the NFA firearm and formed the trust, that makes your client first among many. In other words, none of the other trustees should be allowed to sell or encumber the trust property without the consent of your client, the primary trustee. Next slide, please. This is the catch-all phrase that that shows how broad the trustee's powers are. And it basically says sell, exchange, pretty much do anything else with the property which in the trustee's opinion may be appropriate. And it goes on and on and on, but it's intended to give the broadest possible powers to the trustees unless the drafter of the trust wants to limit it. Next slide, please. Now, here are some of the features that you need to have in an NFA trust. The first thing, and I can't stress this enough, is that you need to thoroughly consult with the client before drafting the trust. If the client doesn't know much about guns, you better educate the client because he might inadvertently commit a federal or state felony otherwise. If the client's loved ones don't know much about guns, well, then there's going to have to be something done to educate them if they're going to be trustees. If your client doesn't know much about gun safety, NFA firearms can be more dangerous than normal guns, so you better make sure your client takes some step to acquire those skills and knowledge to safely own those items and store them. So thoroughly consult with the client. Find out what the client's knowledge is of guns, gun safety, and gun laws. Find out what the potential trustees and other loved ones' knowledge is, and find out if anybody is a prohibited person. The second thing, as I mentioned, it's based on a standard living trust form. Those forms normally have provisions in there that deal with marital property issues, with whether the trust can own the homestead and things like that. I don't want to cripple my trust, so I leave all that stuff in there, but I advise a client normally not to put anything in there other than NFA firearms and accessories that go with those firearms. The reason for that is that if there's ever a problem with the NFA firearm and the government wants to try to forfeit those items, that you don't have the client's house and cars and investments and things in that trust. It just limits the damage there to the NFA firearms and then accessories that just go with those firearms. The trust needs to be legally valid. There's a merger doctrine that says that if the general principle of a trust is to separate the right to control a trust property from the right to receive the benefits. If those rights merge and if the same person is the only trustee and the only beneficiary, then the law applies common sense. I know it's rare, but it actually happens in this case, and says there's no need to have this trust. We're going to just say that the result is there's no trust and the beneficiary owns the property directly. That's a problem if it's an NFA trust because there's no trust and now you have an individual who's possessing that firearm. So you've got to make sure that there's never going to be a merger if that doctrine applies in your state. So make sure there's always at least one trustee who's not a beneficiary or at least one beneficiary who's not a trustee. You also need to consider the client's estate plan to make sure there aren't any conflicts. Again, educate the trustees about the legal requirements and make sure that the trustees, that your client knows that that has to be done if you're not actually dealing with the trustees. And then finally, as I mentioned before, limit the other trustees' power to transfer NFA firearms because normally a person that goes to the trouble of forming one of these trusts is going to consider those to be family heirlooms and want to keep them in the family. Next slide, please. Now, a trust is not a business entity, so you cannot confer limited liability like you can with a corporation. However, you can take some steps to reduce the likelihood of having big public fights. I like to have an arbitration clause in my trust, and there's some other provisions that relieve the trustees of liability under certain circumstances. You need to specify whether normal wear and tear, whether the trustees are going to be liable for that if they use the items, and there's a gun, an expensive gun breaks. Well, then what happens with that? You need to think about these things. As usual with the trust, you need to maximize the client's control of the trust and the assets. You need to predict the future and make the structure of the trust as flexible as possible. You need to address as many what ifs as possible because these things could be in place for more than a lifetime. Another consideration that's really important is to maximize privacy because gun owners generally don't want their affairs and their gun ownership made public. And then finally, I charge what I consider to be a fair fee to this for doing this. I've got to give enough value to justify that fee. So if there's a form that I know the client's going to need in the future, like appointing or removing a trustee, I'm going to go ahead and provide that form so that the client doesn't have to hunt me down and pay more money to get something that I could have given him from the beginning. We'll talk a little bit more about the business aspect of this down the road. Now, I mentioned limited liability for corporations. That makes the idea of an NFA corporation very attractive because, after all, we're dealing with firearms here, which can be dangerous and could involve some liability. NFA corporations are specifically authorized by the tax code, just like NFA trusts. They do confer limited liability, assuming that your state does that. But there are some drawbacks. In Texas, you have to file a franchise tax report every year and a public information report that identifies the officers of the corporation. That can be a privacy issue, and it's also, there are consequences if you don't do those each year. Probably a third of the time when I become involved in a lawsuit against an entity, the entity has had its charter revoked because somebody didn't file the necessary paperwork. Creates a lot of danger just in terms of normal liability, but if the corporation or other entity owns NFA firearms, it means that your client could be a felon. So I only recommend formation of an NFA corporation or entity if your client is one of those people who always gets his paperwork done every time, on time, without fail. If your client isn't that person, then I don't think the trade-off is worth it for limited liability versus an inadvertent felony. I know states have different amounts of information that are placed on the internet regarding corporations and entities, but if you look at the Texas Comptroller's website and look up Healy Law, you'll find the physical address, you'll find my name, you'll find the state taxpayer ID, the registered agent. That's not a good thing if the corporation is formed for the purpose of owning guns, especially if you ignore my advice and put something in the name of your corporation that references guns. So you need to take a look at that in your state and make sure that you maximize the privacy of your client. You definitely don't want to give a roadmap to the bad guys of where they can go find a machine gun or a suppressor. Next slide, please. Here's where you can look those matters up on, from Texas. The first line is the URL for looking up entities. You can find the name and address. You can find the status of whether it's in good standing or not, the registered agent, the date of registration, and then even the names and addresses of the officers and directors. Next slide, please. There's a paid website in Texas where you can get even more information. You can actually pull up the corporate documents that are publicly filed. You can find associated entities. You can search under the individual's name and find other entities that are associated with that person. Your client needs to make a conscious decision of whether to put this much information out there about an entity that deals with guns. Next slide, please. Now, let's talk about the regulation. The regulation became effective in 2016, and it significantly changed the process of registering and owning NFA firearms. The first thing it did is it made a definition of responsible persons, which basically includes trustees of trusts, probably also settlors, and then officers, directors, and managers of business entities, basically anyone who can possess or make decisions about the NFA firearms. It also imposed a requirement when you send an application into ATF for these persons to complete a responsible person questionnaire. So hypothetically, I want to form a trust to buy a suppressor. So I form the Sean Healy Family Trust today. Tomorrow I go to my NFA dealer and I say, I want to buy a suppressor, and I like that one right there. So he'll help me fill out the Form 4, and I'm going to be a trustee of that. I'm going to make my legal assistant Tyler a trustee. I'm going to make my wife a trustee, and I'm going to make my adult stepson a trustee, because they're all in my family members are in my house and they have access to these to the gun safe. So I want to make sure that they're legally allowed to possess these items. So I complete a responsible person questionnaire for each one of those persons, attach it to the Form 4, send in the $200 payment, and then I submit my Form 4. As of right now, the last time I checked, it's taken close to a year for ATF to process these applications. So we wait for a year, and then we get it returned with a tax stamp, which means it's been approved. So at that point, I go back to my dealer, and I show him the tax stamp, and I take possession of my NFA firearm. Now, if I want to change trustees after that, I can do it, and I don't have to get anybody's permission or notify anybody. But the next application I send in to ATF has got to give the current information and a current copy of the trust. So this is a very important thing to know. You don't have to get the government's permission every time you change trustees. It's just every time you send in an application, you have to include all the required information and make sure it's current. Now, the next thing that the ATF docket did, the new regulation, is that it removed the old requirement of a CLEO signature and replaced it with a CLEO notification. Before this regulation, a person wanting to transfer an NFA firearm had to go get their local law enforcement officer, which is the sheriff, prosecuting attorney, people in those positions, to sign the application saying, number one, as far as I know, it's legal for that person, the applicant, to possess this item in this jurisdiction. And number two, I'm not aware of any reason to believe this person is going to go break the law with it. Well, there's no requirement for CLEOs to sign them. And so you have a patchwork of states where NFA firearms are legal in some states, but not in others. And within the states where they're legal, you had another patchwork of counties, some of which allow you to own NFA firearms, and some of which you didn't. This regulation eliminated the patchwork within a state by taking away the law enforcement officer's right to veto your application by withholding a signature. So instead of a CLEO signature requirement, now you just have to send a copy to the CLEO when you send in the application. If for the CLEO where the trust is going to be located gets a copy of the application, the CLEO where each responsible person resides gets a copy of that person's responsible person questionnaire. So they're just notified that somebody in their jurisdiction is trying to acquire a suppressor or machine gun or SBR or whatever. So that's a second change. The third change is actually a codification of the ATF's policy, and that is that personal representatives such as executors and administrators are allowed to possess the decedent's NFA firearms, quote, during the term of probate. ATF had, without any statutory authority, ATF took a reasonable position and actually published it on their website. And they said they were doing this before, but now there's actually a regulation that makes this legal so your clients can count on it. And if anybody's dealt with ATF, they know that ATF can change its mind in a heartbeat. This kind of commits them to that policy and gives that legal protection to the clients. The fourth change is an exemption. And what that says is that if your trust or business entity has had an application approved in the last 24 months, then you don't have to resubmit the same information if it hadn't changed. And that includes the responsible person information. In addition to the responsible person questionnaire, each of those persons also has to submit fingerprints and photographs as a part of the application. So if your trust has had an application approved in the last 2 years and none of the information has changed, you can just check that box and rely on that previous information and not have to resubmit it. And finally, this is what I mentioned before, nothing in the law requires ATF permission to change trustees or corporate officers or directors. The requirement is when you send in an application, the information that you send with it has to be current and complete. It doesn't require you to send it. It does not require you to send information in when you're not applying for a transfer of some sort. Next slide, please.
Sorry, I'm having
Okay, there's another step forward that ATF took. They established an electronic filing system. In the past, you had to send in 2 complete copies of your application with fingerprints and photographs. They established an electronic filing system in 2013. They have had a lot of problems with this system. Once it's back up and running, it will hopefully make the whole system run more smoothly, make it easier to submit these applications, and make it easier and quicker for ATF to process them. But to give you a basic history of this, it started out speeding up the system, and ATF, they have a big pile, at least figuratively speaking, of applications. And that's why it takes approximately a year now to process an application, is because they have a backlog. Well, they hired a bunch of new examiners to look at these applications. They basically tripled the size of that department. And they actually started cutting into the backlog, and they got down to where the applications were taking 5.5 months or so to process. They had problems with the system, and they also had people that were uploading a lot of forms electronically, and the system got to where they had to reboot it every morning, and they lost whatever was in the process of being uploaded. So they took the system down, and they hired a contractor to work on system 2.0. Now, as of right now, the system is not available for Form 4s or even for Form 3s, which is a dealer-to-dealer transfer. So it's not available to normal citizens trying to file an application. When it was available, they did not require fingerprints or photographs for trusts. They don't let you send scanned copies of fingerprints or photographs. So at that time, they allowed electronic filing of trust applications, but they did not allow electronic filing of individual applications. Now that fingerprints and photographs are going to be required for all applications, hopefully they'll make the electronic filing system available for that once it's back online. But they're working on this, and once they get it up and running again, it should speed up the system. And also, my attribution of the reasons for the increase from about 5 to about 12 months of processing time is because after the 2016 change was made to the regulations, ATF has a lot more work to do with all these applications. In the past, they didn't have to do serious background checks on trusts, and now they do. They have to run the fingerprints and all that. So they've made a lot more work for themselves, and they're trying to get caught up. Hopefully they're going to get that done and get e-filing back up and running, and then the processing times are going to drop because, you know, honestly, there's no reason. We have an instant check system for most guns. You can walk into a gun store and fill out your information, and they have a system that allows them to instantly check to see if you're on the list of prohibited persons, and you can walk out with that gun if there's not a reason to hold up the sale. There's no reason why the system shouldn't be the same way for these items. Next slide, please. Here's some drafting notes on NFA trusts. Number one, as I've said before, please conduct an adequate consultation with a client. That means you're going to have to budget an hour or so at least for a consultation on each of these, which means you're going to have to charge more for it. There are some lawyers who charge less than $200 for an NFA trust. I've gone through and written letters explaining why those trusts are invalid, and some of those letters are 5 pages or more long. Do a thorough job. The consequence here of a mistake by the lawyer can be a 10-year prison sentence for the client or one of his loved ones and a $250,000 fine. Given those stakes, what risk do you have if you commit malpractice? That's a lot of money for a lawyer to have to pay out because his client went to prison because of a mistake the lawyer made. These gun laws are zero tolerance gun laws. They're strict liability. If you commit a paperwork violation, you can go to prison. You got to know what you're doing. You got to know your client's circumstances, and you got to do a thorough job of drafting the trust. Second thing is, if the client is not knowledgeable enough to do this, you need to help them get knowledgeable enough, and also help your client get the other trustees up to speed on this, because you want to make sure they don't break the law. You start with a form and you take those 6 legal principles and you go through and you rewrite every sentence in your trust form to take those 6 principles into account. This structure, I like to compare it to a playpen. You're building a playpen that holds your client and his family members in, that keeps them from getting out into dangerous places where they can break the law. If your trust is well drafted, it won't allow the trustees to violate the law, and it definitely won't instruct the trustees to violate the law. A lot of the cheaper, less thorough trusts out there actually tell the clients to commit federal felonies, and obviously that's a bad thing for your malpractice exposure and for your client's freedom. Customize the trust to your client's specific needs. Try to limit civil liability, avoid criminal exposure, and provide a firewall for forfeiture issues. And then do the things we do for every trust client. Try to predict the future, create a structure that's as flexible as possible, and do a good, thorough job for your client. Next page. These are some of the ancillary documents that need to be included with the trust. I have a very long letter that explains, it's about 13 to 15 pages, that explains the basics of the law to the clients. That letter became a 40-page CLE paper on NFA trusts, and that provided a lot of the substance to the book. In fact, I like to hand out the book to clients because that shows that you made an effort to inform them of a lot of this stuff. So a letter of explanation is critical, and I believe the book includes an older version of my letter. A removal of trustee. If a trustee, if a protective order is filed against the trustee, or he gets indicted for a felony or something, you need to remove that trustee immediately. The client doesn't need to have to hunt you down and come pay you another $100 for a removal of trustee form. If you're gonna do a good job of this, give them that form. Appointing other trustees, give them the form. Changing beneficiaries, give them that form. Assigning property to the trust or removing it to the trust, that gives a written record of what trust property is owned. And then finally, some parties, you want to affirm that there's a trust out there and give them some basic information about it, but you don't want to give them all the information. I like to provide a declaration of trust that doesn't mention guns. It gives some basic information to bankers and people about the structure of the trust. I believe all these should be included with the trust if you're going to charge a decent fee for it. And they're easy to put together too. Next page. Now, NFA trusts were originally formed years ago for a couple reasons. One of those is people who lived in jurisdictions where their CLEO wouldn't sign their paperwork, they could still own NFA firearms by forming a trust. Because in those days, if you formed a trust, there was no need for the local law enforcement officer to sign off. That advantage is gone. Later on, they were also used because they were processed more quickly because there was no requirement for fingerprints or photographs. And ATF did a background check a lot more quickly than the local people. So trust applications were processed a lot more quickly than individual applications. Again, that advantage is gone now that we have to provide responsible information, responsible person information with the application. There are 2 advantages that only come with a trust or an entity that I think justify this. Number one is it protects the client's loved ones and friends from prosecution. If someone has access to the firearm as a trustee, there's not a problem there. If the NFA firearm is titled in an individual's name and another person has access to it, then that person could get prosecuted for having constructive possession. So this protects the loved ones and friends from being prosecuted for a felony. Second thing is, it's the only way to allow other persons to use and access NFA firearms. If the person's a trustee, he or she can take that suppressor out to the deer lease and use it, no problem, that's lawfully possessing it. The third significant advantage, and I think is probably the most significant one here other than those 2, is the estate planning advantage. A lot of gun owners believe their guns are family heirlooms. They want to preserve them for future generations. This allows you to do that, and some people are even drafting gun trusts for normal firearms that are not NFA firearms. There's some other advantages that are listed there, but my belief is that an NFA trust for most people is the best way to own NFA firearms. And so I think they're still viable if you can explain these advantages to the client. So at that point, I would go ahead and open it up for questions. And Alan, I guess you go.
Yep. This is Deb Erdman again with Peak Trust. Thank you so much, Sean and Alan. That's really amazing information, and thank you. We have a lot of questions. So I'm just going to let everybody know we try to keep the webinar within an hour, which we did. Perfect. But we have a lot of questions. So if you'd like to stay on, we're going to be taking questions probably for the next 15, 20 minutes if Alan and Sean are open to that.
Sure.
That's
Okay.
fine.
All right. We'll jump right in then. The first question is from Gary Duell. And he asked, but don't legally owned automatic weapons get illegally transferred?
Do they get legally or illegally transferred?
Illegally. They're legally, but if they're legally owned automatic weapons, don't they get illegally transferred?
My understanding is that that's very rare. If a person goes through a background check, submits an application, pays $200, and probably spends $15,000 to $25,000 on a lawfully owned machine gun, that normally those people educate themselves about the law, and they're very, very law-abiding. So I think that's extremely rare that that happens.
Okay, and next question, and it's kind of a two-pronged question. By tax code, do you mean Internal Revenue Code? And if so, what sections? And that comes from Stephen Wiley.
I don't have my paper up on the screen, but I cite all the different sections in the paper. Yes, I am referring to the Internal Revenue Code.
Okay, and we'll be sending out a copy of the slides to everyone. Next question is from Timothy Brown. What if a person has had their record expunged of a felony? It was in the early 80s and they followed through with the judge's order. They have never been in trouble with the law since.
That's a matter of state law. And in Texas, you can have an arrest expunged, which means basically wiped off your record like it didn't happen, but you can't have a conviction expunged. And Texas has the only procedure for something like that is called deferred adjudication. And there's a certain type of a deferred adjudication where at the end of the case, once the person has fulfilled their conditions of probation, the judge goes back and dismisses the indictment, vacates the judgment of conviction, and restores all the person's rights. Under Texas law, the Supreme Court for Criminal Matters of Texas, we have two Supreme Courts in Texas. The Court of Criminal Appeals, which is the Supreme Court for criminal cases, has held that that type of deferred adjudication, when it's successfully completed, is not a conviction. The federal statute specifically invokes state law and says if state law considers it a conviction, then we'll consider it a conviction. If state law doesn't consider it a conviction or considers that the rights have been restored, then we're going to honor that too. So the answer is it depends on your state law.
Okay. So the next question is, and actually the slide is up. Someone wanted us to provide the discount code again, and as you can see, it's right here on the slide, the promo code. And again, a copy of all these slides will be provided to everyone within 24 hours after this webinar.
And if anyone wants additional information from me after the fact, feel free to contact me by email or whatever, and I'll do my best to answer your questions.
Well, thank you for that, Sean. And his contact information, folks, is up on the screen right now. Next question is from Valerie Fishgold. Under Texas statute, I'm confused. Did you say that things such as switchblades are prohibited by anyone, including a gun trust?
Well, switchblades have been removed from that Texas law since then. That's an old feature from a prior version of the PowerPoint presentation. The Texas law governing prohibited weapons includes, and I'm not looking at it right now, but approximately 8 or 9 different items. The first 4 of those are roughly equivalent to 4 categories of NFA firearms. And then the rest of them are not NFA firearms, but they're still prohibited under Texas law.
Okay, next question. Do you have a recommendation on how to get insurance coverage for the trust? And this is from Donna Gonzalez.
It depends on what type of insurance you're talking about.
Okay.
I would suggest a two-pronged approach. If it's conventional insurance you want, and this would be more applicable to like an NFA corporation or something, but if you're looking for general business liability coverage or some type of casualty coverage or something, you can just go to your business insurance agent. But there are a lot of gun-specific insurance policies that are available through the NRA. For instance, as an instructor, I think I can pay $300 and have a multi-million dollar policy cover all my instructional activities. There also are policies that are specifically made to cover firearms. So I would go both ways and check that.
Okay. Next question is from Douglas Bauerband, and there's two questions. What is the cost of one of these trusts to have written up? And do you write these trusts, or do we have to go to our own attorney?
Well, each lawyer is going to set his own fees. I prefer to set a flat fee for things like this because clients like to know what they're going to pay, and it attracts more business, frankly. So my fee, generally I charge $750 for a basic NFA trust, and I include the 5 ancillary documents that are mentioned in the PowerPoint. If the client has a complication, then I will basically add on custom work at my normal hourly rate. So for instance, if we have 5 police officers get together and they want to use the same NFA trust so that they can freely borrow each of their NFA firearms, but they want to have it drafted so that each one basically preserves the right to pull his own NFA firearm out and sell it or do whatever, rather than making that some collective right of the trust, then I charge extra for that work. If somebody wants some elaborate multi-generational trust to preserve all their guns and let future generations of family members, use those guns from the trust and have firearms education offered by the trust, maybe mix some money in there for that or whatever, then I charge what it costs me to do it. You're competing with attorneys who charge less than $200 for a trust, and actually there are some NFA dealers that are practicing law by offering attorney drafted trusts for pittance of money, $20 to $50 on their websites. There is a serious danger with these. One danger is that a lot of them allow, sometimes actually instruct the trustees to break the law. Another one is when you copy something, there's nobody who's responsible if it goes wrong. The attorney for ATF who reviews these trusts gave a speech at the NRA annual meeting, and he said they've gotten several thousand trusts which are identical except for the names of the settlors and the trustees and the property to be transferred. They're all the same form except a bunch of different people are sending them in. Well, they didn't change out the beneficiary's name. So there's some woman who resides in Kansas who is going to start effectively inheriting thousands of NFA firearms when these trusts terminate, just because somebody was lazy and they got on the internet and took a free form. So you need to charge what you're worth. And if a client goes to the $200 lawyer instead of you, then that's good riddance. I don't want to do this for $200. It's not worth it for me. The responsibility and the time commitment is too high, and I have to recover the time that I've put into coming up with these forms and modifying them over the years.
And Sean, this is Alan. I'm going to add that we are charging at least $2,500 to $3,500 because we're spending a lot of time with our clients and spending a lot of time customizing these forms. So $750 is way below market for a lot of the people on this call.
Okay, and he has a follow-up question too, is do you write in all states and New Jersey being one of them?
What I do is if someone wants to work with me if an attorney wants to work with me in another state, then I will make a deal with that lawyer to use my forms and back them up and help get them up to speed on it and everything, and basically split the fees with them. But they're going to be responsible for compliance with that state's law. And then if I get a customer or a client who calls in and says, I'm in New Jersey and I read your book, can you do a trust for me? I'm gonna send it to that lawyer. And if that lawyer gets another client who comes in and he wants to use my forms, then I just use the honor system and trust him to follow through on our deal.
Okay, thank you. And next question, if one does not have NFA qualified firearms, but does own a collection of older Colts and Smith & Wesson revolvers of significant value, is there a need to create a gun trust rather than specify distribution through a will?
Let me add one thing to the last answer before I answer that.
Okay.
Interactive Legal is it's a knowledge program and a support program, and it's also a document assembly service. Along with Jonathan and some other lawyers, I put together the NFA Trust module for Interactive Legal, and where we're selling it, I think it's customized for that state so that you can go through and type in the information on the names of the trustees and the settlers and stuff like that, and it'll automatically change the gender and insert the names where they need to go, and then you can select whether to include certain sections and paragraphs or not. So that's an easy way to get up to speed with forms that are tested and true. To answer the next question, this is a question about a gun trust that is not an NFA firearms trust. And the answer to that is, this is becoming, it's probably the fastest growing area in gun trust, is forming trusts to own normal firearms. If you look at those 6 legal principles at the beginning of the paper, I think it's on page 15 of the PowerPoint. If you just take out the ones that relate to the National Firearms Act, that leaves you with the reasons why an ordinary gun trust might be desirable. Let me try to get to that real quick. Okay, it's page 14 of the PowerPoint. The first one only applies to the NFA. It's not illegal for me to let someone else possess an ordinary firearm. So if I have a pistol in Texas, it's legal for me to loan that or sell it to somebody else. The number 2, the procedures for transferring an NFA firearm, those don't apply here, so you don't have to worry about that. The prohibited persons part applies, and the benefits of forming a trust, of preserving those guns for future generations, and of helping educate the client on the applicable laws and all that, many of those advantages apply to gun trusts. So if you have a client who has a gun collection and wants to preserve that heritage for future family members who are interested in hunting and shooting and things like that, a gun trust is a good vehicle to do that. Just if you have the rule against perpetuities in your state, then make sure that you draft the trust so that it doesn't run afoul of that. That's the fastest growing area in this practice.
Wow, very interesting. And the next question is, a firearm that is identified in a trust subject to confiscation years later if it is a type that falls within the specification of the confiscation order?
Let me try to interpret that. If there's some court order, like a forfeiture, then if for some reason the government sues the trust or the trustees, saying that, for instance, one of your trustees loaned the gun to his buddy and his buddy drove around shooting street signs with it, and now they want to forfeit that machine gun, then assuming that the prerequisites of the forfeiture law were met and the trust was properly served through a trustee and all that, I think it would be subject to that judgment and have to comply with it. If the federal law changes, for instance, and says suppressors are now illegal for anyone, then this doesn't get you around that law. If the state law changes, then it doesn't get you around that law. Hopefully you'll have enough warning to where you can either move that firearm out of the state or sell it to somebody and get some value for it, or do something else to avoid, violating the law. But once that law becomes effective, if an item of trust property becomes illegal, then putting it in a trust is not going to make it legal. I hope I answered that question.
I think you did, because it's a very complicated question, especially when it talks about confiscation and assets in the trust. So, but with that, we've got a lot more questions to answer, but I think we've used up all the time. So anybody that didn't get their questions answered, we will respond after the fact. We have your contact information, and we will ask if Sean or Alan would be willing to possibly reach out to you and answer these questions. And we really want to, on behalf of Peak Trust, I would like to thank Sean and Alan for all their time today. Their expertise in this topic is amazing. And from the interest, it looks like we may be doing some follow-ups on this. So again, thank you on behalf of Peak Trust. Sean and Alan, any parting words?
I appreciate all your help, and Alan, for the hundreds of hours, maybe more, that you've put into this and helping get the book going and getting word out to everybody. Straight from my heart, man. Thank you so much for everything you've done.
It was nothing but fun, and let's thank Peak Trust Company and their family of advisors. Wonderful, wonderful people. Please consider using Peak Trust Company, because they know more about these trusts than anyone anywhere. And the forms library on their website is really amazing. Thanks again.
Yes. Well, thank you for that, Alan. And thank you again, everybody, and have a wonderful day. And remember, within 24 hours, you will get a copy of these slides and a copy of the recording of this webinar.